So, going into the world of estate litigation, say, an example, say an executor was proposed and I didn't agree with the alignment of that, the appointment of that executor. How might I challenge that? How might I go about?
Well, I guess the short answer is you can't really go challenge the appointment per se, unless you're challenging the validity of the document. We talked about some of that before, but where people and I get a lot of clients that come in and see me and are kicking off because their brother or sister's been appointed the executor of the estate, and they're just completely doing the wrong thing. They're dragging their feet. They're undervaluing assets. There's always a deep-rooted family history of distrust between the parties, and there's always an issue, right?
And whatnot.
And you sit there and you listen to the story for about, I don't know, half an hour to an hour. Almost 99% of it's not really relevant, but
you think you should be a counsellor?
Well, yeah, part friend, part lawyer, part counsellor, part accountant, part everything in this job. But basically, what I tell clients is that if the will is valid and the executor has been appointed and chosen by the deceased, and they're administering the estate for a reasonable period of time to administer the estate, and I explain the process and how long things take and what is reasonable and what's not reasonable. For example, having an estate that you've been appointed as the executor and you've got probate of the will, you've had the assets for 4, 5, 6, 7 years, 10 years, 20 years in some cases, and done absolutely nothing with them. That kind of getting into the realms of unreasonable, whereas you might have quite a complicated probate application or something with some issues in getting probate, and it's taken 12 months or whatever to get the grant, just to get your authority to start dealing with the thing. So it's all relative and what's reasonable, but if you could, in theory, challenge the appointment on the basis that the appointed executor has a history of criminal wrongdoing, a history of fraud. They might have a history of drug addiction issues or alcoholism, or a serious problem that will jeopardise the proper administration of the estate. But you'd really want to have some direct evidence of that. You can't just make up a whole bunch of allegations.
Sure.
And then another way of looking at removing an executor or questioning decisions of executors is to call for them to account to you in the administration of the estate. And if there are problems and big gaps in what they're actually doing, spending money on, then you might be able to have them removed in that circumstance. But really, it's got to be an executor owes a fiduciary duty to beneficiaries because they're in a position of trust. And an example might be if an executor sells a property for significantly less than the market value, that can cause a wasting of an estate or damage to the estate. They might have a personal interest conflict. So, for example, they might sell or transfer a property that belongs to the estate to themselves. I've had ones in the past where the executor was operating their own business out of the deceased's property and not paying commercial rate of rent for periods of time, or there might be farming property where they've been farming the land for 10 years or so, and that causes a problem there in terms of the income that could have been generated for the estate. The other issue is the valuation of the property. So if the beneficiaries have said, no, sell, I want the house sold or whatever, and the property prices are at their peak and they've been told to sell it and they do nothing, if the property prices then drop down, or shares is another example because they're changing all the time, if those assets devalue significantly, then they may have a cause of action against the executor. Arguably, to remove them. So, but from experience, executor type trustee disputes are very expensive in terms of legal fees.
Yeah.
They're grubby, and they take forever to get over the line. And it really has to be some clear wrongdoing for the court to say, well, because their court's already appointed them by the order, by the application. And you want us to undo an order that we've already done. Come on, where's the evidence